Should we waiver, can we say something so we know? Try and say something again.
So Jane, what I tapped, can you hear me?
We're able to hear you.
Pardon me?
We're able to hear you. Can you hear us?
Okay. Yes, I can. Thank you.
Yes, we're able to hear you.
Pardon me?
Can you hear us?
I think we've got
I can. I can. You're going in and out a little bit.
Judy, can you hear us and see us?
I can see you.
Okay.
Well, actually, I can't see you. I can see Walker and Commissioner Bluestone.
Can you hear us now?
I can hear you now, yes. I've been able to hear you all along, I think.
Okay, I think we're ready to go.
Hear me? Apparently not.
Were you asking me?
Yeah. Bill, can you hear me?
Intermittently. If you talk a little more, maybe I could get it'd be a longer test.
DDGHIJK.
Yes.
Then, that being the case,
Chairman, excuse me, if at any point that I can't hear, I might not be able to hear you. Is there some signal you want me to, maybe I should, say I can't hear you or something?
offensive gesture.
Okay. Oh,
I'll here to order, here in the Eichenberg versus Montoya, 2022-006. A roll call of the commission is in order. Commissioner Baker.
Present.
Commissioner Bluestone.
Here.
Mr. Castillo.
Here.
Commissioner Miller. Here. Mr. Solomon.
Present.
Commissioner Villanueva.
here.
There is an agenda that has been provided to everyone. Is there a motion and second to approve it?
So move.
Second.
Any dissent? All those in favor?
Aye.
Opposed? Hearing none, the agenda is approved. Now we will move on to oral arguments. By my calculation, the notice of appeal, the first one, Mr. Boyd, was you. But would you please state your appearances and on his behalf, you and with any co-counsel are appearing?
Afternoon, Chair and Commissioners. This is Walker Boyd. I'm here as the Commission's General Counsel, having intervened as a party in the proceedings below. With me to my left is Jessica Randall, Deputy General Counsel.
Thank you.
Good morning, Mr. Chair and Commissioners. My name is Ken Stalter. I represent Treasurer Laura Montoya, who is present.
Thank you. Good morning, both of you. All righty. Any preliminary matters, counsel?
And with respect to oral argument timing, Chair, there's been an appeal and a cross appeal. Whoever goes first, I suppose, will use their time in a rebuttal thereafter, but it could get a little awkward, I guess, if we've got two separate tracks here. So if the commission wants to consider that, it's still.
I think we can figure out how to do that if it becomes an issue. It shouldn't protract. But is there any opposition? My thought was that 20 minutes for each side, divided how you want it sufficient. Do you have any opposition to that, Mr. Stalton?
No, sir.
Boyd?
No.
Okay, go ahead, Mr. Boyd. And I would ask you to just, in terms of all of your arguments on either side, divide the time as you wish. And I'm not going to hamstring anybody to get up and you hear something for the first time on basically rebuttal, you're going to have a time to sort it out.
Right. And my understanding, Chair, is I have 20 minutes for my main and up to 10 minutes for my rebuttal. That's what I communicated to James. That correct, or should I reserve some additional time?
I was thinking 20 minutes and for the whole thing. If you have,
That's fine with me.
you okay with that?
Yeah.
Yes.
Yeah. If And if there are questions from the panel, it's always best if you can hold them, but there may be something you need clarified, just get the chair's attention and we'll take care of that, okay? But it's, I would prefer if we waited until the end, but there may be something that needs clarification. Go ahead, Mr. Boyd.
All right, good morning, Chair and Commissioners. The Commission today in this appellate proceeding has to answer two questions. The first question is whether there was substantial evidence for the hearing officer's decision that respondent Laura Montoya violated the law. And the second question is whether the hearing officer correctly declined to order a respondent to forfeit the unlawful $10,000 contribution he found she had received. She had received knowingly. On the first question, the hearing officer's finding of a violation should be affirmed as supported by substantial evidence. The complaint alleged, and at the hearing, the issue was respondent accepted a concealed or a straw contribution from a property developer named Gary Plant that was made to her through a conduit, a political committee called Adelante Sandoval. And second, respondent failed to report contribution's true source, instead reporting Adelante Sandoval as the source of the $10,000 contribution on her report of contributions. And the undisputed facts at the hearing established those violations. First, it was undisputed that respondent at all relevant times was a candidate seeking an office covered by the Campaign Reporting Act. She was covered by the Campaign Reporting Act. And second, it was undisputed that on September 21st, 2021, respondent, Donnie Leonard, then a volunteer for her campaign, Gary Plant, the original source of the contribution, and others met at a cafe for lunch in Corrales. At the lunch, respondent solicited contributions from those present. Third, Gary Plant paid for the lunch and told respondent that he would be supporting her campaign. After the lunch, Gary Plant went to the bank, accompanied by Donnie Leonard. Mr. Plant obtained two cashier's checks of $5,000 each from the bank from accounts owned by two LLCs that he controlled. Importantly, Donnie Leonard, the volunteer, told the bank teller who to make the checks out to, Adelante Sandoval. This is according to the deposition of Gary Plant. Chris Dahl, fifth, Gary Plant gave the checks to Donnie Leonard, and the checks were delivered to Chris Dahl, the manager of Adelante Sandoval. Sixth, Chris Dahl testified at the hearing that someone representing respondent's campaign, either respondent herself or Donnie Leonard, told him that Adelante Sandoval was to use the funds to make a contribution to respondent, and that Adelante Sandoval was being asked to serve as an intermediary because the Plants were private people. On the same day, September 21st, 2021, respondent sent a text message to the Secretary of State, Maggie Toulouse Oliver, asking how to report a $10,000 contribution from a political committee to her campaign. Again, on the same day, respondent sent a text message to Chris Dahl, the manager of Adelante Sandoval, containing a screenshot of that conversation, a thumbs up emoji, and a thumbs up emoji. Respondent testified that consistent with that conversation, in which Chris Dahl tells her to call him, she likely had a phone call with Chris Dahl that day. Finally, Chris Dahl caused Adelante Sandoval to give a $10,000 contribution to Laura Montoya's campaign several days later. Based on this and other evidence at the hearing, and after seeing live testimony from both the respondent and Chris Dahl, the hearing officer found that respondent had knowingly accepted a straw contribution, i.e. a contribution made by Gary Plant in the name of another person here, Adelante Sandoval. Now, respondent's main argument on appeal is that Chris Dahl's testimony as to how he understood how he was given instructions about what to do with the contribution was inadmissible hearsay. This argument fails for two reasons. First, the statute, section 11934.3A in the Campaign Reporting Act, prohibits the making of a contribution in the name of another person. and it prohibits a candidate from knowingly receiving that kind of a contribution. So in order for the hearing officer to find whether this contribution was made by Gary Plant in the name of another person, or whether this was an arm's length transaction in which Chris Dahl had discretion as to what to do with this contribution, the hearing officer needed testimony about why Gary Plant did what he did, which is go to the bank and make a contribution to Adelante Sandoval after this fundraising luncheon, instead of just giving a check directly to Laura Montoya at the lunch. Also, why Chris Dahl did what he did, which is give the money to Laura Montoya several days later and not to any other candidate that Adelante Sandoval supported. So Chris Dahl's testimony that he was told that the plants were private people and that he was being nominated to serve as a conduit for this contribution for that reason is not being offered to prove the truth of any of those statements, but instead to show the knowledge and motivation of the parties involved in this transaction. And importantly, it goes to the knowledge of Laura Montoya. Laura Montoya, to be found to have violated the Campaign Reporting Act, needed to be proven to have known about this contribution when she received it. So that all evidence all goes to a different purpose than the truth of any of the statements contained in that conversation. Finally, as the briefs explained, the statements were likely made by Laura Montoya, who was a party to these proceedings and therefore offers an independent basis for their admission, or Donnie Leonard, who was serving as her agent at the time. I want to go next to what the hearing officer did. The hearing officer heard all this evidence and under the State Ethics Commission Act was required to do two things. First, decide whether a violation had occurred. And second, if a violation had occurred, whether to impose a civil penalty as provided by law. The hearing officer answered those two questions, yes. The hearing officer found yes, that there had been a violation, and two, that a civil penalty should have been imposed. But the hearing officer declined to impose a sanction that amounted to a forfeiture of $10,000 that Laura Montoya had received. The hearing officer appears to have agreed that the factors set out in the federal case law governing unlawful contribution should apply, and specifically mentioned bad faith and public harm in declining to award a sanction of forfeiture. But there are two other factors. One, vindicating the relevant agency's authority to enforce the statute, and the respondent's ability to pay. So before I get to the two factors addressed by the hearing officer in his findings, I want to just briefly address those factors. With respect to vindicating the commission's authority, the commission should consider that this case did not involve a mistake of law or a failure to report. The hearing officer found that respondent knowingly received a contribution in the name of another person. And that's conduct that's specifically prohibited in the Campaign Reporting Act. So the commission, this violation involves a sort of category difference from your ordinary negligent failure to report. This was knowing unlawful conduct. Second, on ability to pay, respondent states in her notice of appeal that even though she continues to deny that she committed a violation, that she was willing to just pay the $1,000 civil penalty imposed by the hearing officer and move on from these proceedings. I think that indicates that the respondent is easily able to pay a higher amount. And that in fact, a higher fine is necessary to communicate to the respondent and other candidates who solicit unlawful, who are asked to solicit and receive unlawful contributions, that the commission will not permit them to keep the benefit of their unlawful acts. On the public harm prong, the hearing officer's findings don't specifically articulate why he found there was little evidence of public harm. On appeal, the respondent argues that there was no public harm because the amount of the contribution, $10,000, did not violate the Campaign Reporting Act's contribution limits. But that's not what the public harm is. The evidence established that Gary Plant probably would not have made this contribution or a contribution of this amount if he was not given the benefit of being able to conceal his role in the contribution. There was record evidence that Gary Plant had made contributions to a respondent in previous election cycles of $100 or $250. This was a substantially higher amount of the contribution. And it's for that reason that this transaction likely took place. So that's the first reason that there's public harm. Respondent also argues that the public could still find out about these contributions by checking the reports that have been filed by Adelante Sandoval. Essentially, looking at respondents' reports, which say, I received a $10,000 contribution from Adelante Sandoval, and then looking up Adelante Sandoval's report and seeing where Adelante Sandoval had reported receiving the contributions. But that would require a member of the public to know what had happened here. As you know, just reading those reports, no one knows that Gary Plant, the manager of these LLCs, intended for these contributions and directed that these contributions pass through Adelante Sandoval to the respondent. And it's for that reason that there's public harm, because again, the public is being deprived of knowledge about who's directly supporting candidates. Finally, on the question of good or bad faith, I want to note that the case law from the Federal Election Commission talks about bad faith and good faith in the context of a respondent's efforts to correct a violation. The Ted Haley case that is cited in my brief involved some fairly complicated loan arrangements where the respondent there was no dispute as to the facts. The respondent had received loans from folks that he thought were not contributions because they happened after the campaign. The FEC then sued him, and there was a dispute as to whether there had been a contribution, and ultimately found there had been a violation. But the court said, well, the respondent had already refunded all these loans and had taken immediate action to correct the violations when they had been found. Here, that's not at all what happened. This case, the respondent continues to deny that there had been any unlawful conduct, and that certainly prevents the commission from finding that there had been good faith. I think also points the needle towards bad faith. Finally, the respondent argues that her conduct was really merely her exercise of her right to a hearing. But again, go back to the hearing officer's findings. The hearing officer found that respondent's testimony was not credible at the hearing. Respondent testified that, yes, there was this. She admitted that there was a close sequence, there was a close temporal relationship between these contributions, but that essentially she had no role. She did, and Gary Plant never gave any instruction to Chris Dahl about what to do with this contribution. And when confronted with these text messages about asking about a $10,000 contribution from the political committee to her campaign, respondent testified that was a hypothetical question. It wasn't about the contribution that Gary Plant was making to Adelante Sandoval that same day. And the hearing officer found that was not credible testimony. And so it was incumbent on the hearing officer to say, given that finding, why there was otherwise some justification to find little evidence of bad faith. And the hearing officer didn't explain that. And so I think that the commission can appropriately look at the whole record of this proceeding and modify the hearing officer's award upward to include forfeiture of this $10,000 contribution.
Mr. Chairman, I have a
Thank
question.
you. Sure. Sure.
Mr. Boyd?
Yeah.
During the hearing itself, were these federal cases cited to the hearing officer, or did the hearing officer find them himself?
Chair and Commissioner Castillo, in my post-trial, post-findings of facts and conclusions of law, I argued that respondent should be sanctioned for the violations, the statutory violations of $1,000 for each violation, and ordered to forfeit. And I argued all four of these statutory factors. Ultimately, it's not just the Federal Election Commission that applies these factors. It's the federal case law where a statute gives discretion to an agency in deciding how much of a civil penalty to impose, either a maximum or somewhere in the middle or very little. Those factors are commonly applied by the federal courts. And that was my argument in the proposed findings. And the hearing officer took two of those, the bad faith and the public harm factor, and applied those, but did not explain either why he wasn't looking at the other two factors or why on bad faith and public harm there was it justified not awarding forfeiture.
And so in your findings of fact and conclusions of law, you put those in there for the judge to choose if he wanted to choose it.
Chair and Commissioner Castillo, I argued those factors in the proposed findings, correct?
Commissioner Bluestone?
Thank you, Mr. Chairman. Thank you, Mr. Boyd. The Federal Election Commission case that you cite, the Furcatch case, it does lay out 4 factors that I understand to be the factors to consider: the good or bad faith of the respondent, the injury to the public, respondent's ability to pay, and the necessity of vindicating the authority of the commission. But as I read that case, there is also a 5th factor that the court approved but didn't deem relevant to apply there. And that 5th factor was the desire to eliminate the benefit derived from the violation. And in that case, there wasn't any benefit that the respondent there derived because he paid out of his own pocket the $25,000 for the ads that were placed against President Carter in the Boston Globe and the New York Times. And he didn't receive any financial benefit or regulatory benefit that was issued to take away. But here, the benefit that was received was the $10,000 contribution amount that was used in the campaign. So isn't it, if there's a balancing of all those factors, when you consider the 5th factor, wouldn't it also have to be relevant to consider that the respondent was able to use that unlawful amount during the benefit of the campaign, and there's been no recapture of that? Is that a fair reading of that case, your understanding?
Chair and Commissioner Bluestone, yes, and I think you've accurately summarized the reason that the court distinguished that factor or found it not specifically relevant to that case. I would also point the commission to the New Mexico statute on this. This is not just federal case law. We've got a New Mexico statute on this, which states that in addition to the civil penalty of $1,000 per violation, there is the legislature has stated that forfeiture of any contribution received as a result of an unlawful solicitation or unlawful contribution may be a sanction, an appropriate sanction. And so I think that setting aside the overarching federal case on this, you've got section 34.6B, which I think demonstrates a legislative intent to deprive candidates of the benefit of an unlawful solicitation or an unlawful contribution.
One follow-up, Mr. Chairman, if I may. But on that point, as the counsel for the respondent pointed out, isn't that forfeiture available as a discretionary penalty? That it may be imposed, but there's no absolute mandatory requirement that it has to be imposed in each and every case.
Chair and Commissioner Bluestone, that is one way to read the statute. I argued to the hearing officer that the statute required forfeiture. However, on appeal, I'm not making that argument. I think that, yes, the hearing officer and this commission has discretion to decide whether to award forfeiture. However, the hearing officer and this commission on appeal needs to state a reason for why it's going to allow the respondent to retain the benefit of this unlawful contribution. If the commission finds that the hearing officer correctly determined that the respondent received an unlawful contribution, the hearing officer was required, and I think did not explain why, nonetheless, the respondent should be permitted to retain that benefit. And if the commission is going to decide to impose forfeiture or decline to impose forfeiture on appeal, the commission should have a reason for doing so. And I think that the statute articulates, I think, a weak presumption here that there should be forfeiture. If there's been an unlawful contribution, then forfeiture should be imposed. However, because of the permissive may in the statute, there is obviously discretion for a good reason for the adjudicating body to decide not to.
And consistent with that, wouldn't it also be an option for us as a commission to remand the matter to the hearing officer to evaluate those 5 factors and to explain the reasons either why no forfeiture should be imposed or what forfeiture and in what amount should be imposed, but to have an explanation offered, and the commission could provide direction on its view on at least some of those factors, but some may involve fact finding, like the ability of the respondent to repay.
Chair and Commissioner Blissa, before I answer your question, I'd just like to note that I'm up at about 17 minutes. I'd like to run a few.
Counting that as our time, not yours, and I'll do the same thing.
Okay, thank you. Yes, the commission under the statute has broad authority to hear an appeal from the hearing officer's decision. Under the regulation, the commission may affirm or reverse, and my position is that in reversing the hearing, the commission can provide instructions to the hearing officer as to what to do, if that's what the commission elects to do. However, I think that the record is more or less complete, so the commission can decide to modify the order based on what it finds, based on a whole record review. However, if the commission believes it needs additional fact finding and the hearing officer needs to conduct further proceedings to make a full set of findings on the 5 factors, that would certainly be within the commission's authority.
Thank you.
Commissioner Baker?
Mr. Boyd, what is your understanding of the commission's ability, if you will, to affirm or reverse what the hearing officer did? We're sitting as a body which is basically being asked to be deferential to what the hearing officer found as facts and what the hearing officer decided in his order. Essentially, I'm asking, how wrong do you think Judge Torgerson had to have been for the commission to reject his findings and conclusions?
Chair and Commissioner Baker, the standard is the whole record standard of review. So that standard of review is more deferential than de novo. The commission is not conducting its own findings of fact. However, it is less deferential than abuse of discretion. I don't think that the commission it is a unbreakable presumption that the hearing officer's findings are correct. Now, what I think the whole record standard review requires is for the commission to look at the hearing officer's findings and then see whether those findings are supported by substantial evidence in the record. Is there some evidence in the record that supports the hearing officer's findings? And in some sense, my job is both tougher and easier because what the hearing officer did specific to the finding of whether to impose forfeiture is the hearing officer just said there's little evidence of bad faith or public harm. He didn't say why there was little evidence of bad faith or why there was little evidence of public harm. And you can contrast that with the other findings, right? The hearing officer made very fulsome findings on the point of the witness's credibility. He had a long paragraph discussing why his job was quite difficult because the relevant witnesses who were parties to this transaction had, strangely incomplete memories about who knew what and when. And the hearing officer had to make credibility determinations, which he, ultimately found that the respondent was not a credible witness and that Gary Plant was not a credible witness. And so I think on the whole record standard of review, the commission is not going to be overturning those findings of fact in order to reach a finding that the hearing officer's decision as to little bad faith was not supported.
In order to reverse what Judge Torgerson did, does the commission have to find that what he did was arbitrary and capricious?
Chair and Commissioner Baker, I believe that the commission to reverse his findings on the violation, the commission needs to find that there was no substantial basis for those findings. So there's no factual basis in the record to make a finding that a violation occurred. I think the same standard applies to the determination of whether to, or in this case, not to impose a penalty of forfeiture. The commission needs to find that there's not a substantial basis for the hearing officer's decision in that. I do not think that the hearing officer, that the standard review necessarily requires arbitrary and capricious. However, those two inquiries might break down to be the same sense, because the commission might view the statute as requiring essentially a presumption of forfeiture for an unlawful contribution that needs to be explained, and the hearing officer's failure to explain why he wasn't awarding forfeiture was arbitrary and capricious.
If I understand your answer, does that mean that both you and Mr. Salter have an equally high mountain to climb? He wants there to be no penalty, no finding. You think the penalty was not sufficient. And so for us to rule in favor of either of you, we would have to find that what Judge Torgerson did was arbitrary and capricious.
Chair and Commissioner Baker, I think that my job is easier because the hearing officer didn't say why he was finding little bad faith or little public harm. Mr. Stalter, with respect, has a harder job because the hearing officer explained why he thought respondent knowingly received a contribution from Gary Plant that was made in the name of Adelante Sandoval. He set forth the sequence of events. He set forth why he believed the text message communications between Laura Montoya and the Secretary of State and Chris Dahl tended to show knowledge. And so Mr. Stalter has to explain why those findings are not supported by the record, which I don't believe he can. And then show that the hearing officer should have picked his client's version of events, that her knowledge was merely about a hypothetical $10,000 contribution, not the contribution at issue. For me, my challenge is the fact that the hearing officer said there's little evidence of bad faith and little evidence of public harm. And I think a whole record standard of review would reveal those findings to be not supported by the evidence.
Thank you.
Mr. Solomon,
I don't have any questions.
Commissioner Villanueva, do you have any questions?
No, I don't. Thank you.
Thank you. Mr. Salter, the floor is yours.
Thank you, Chair and Commissioners. We are here today to talk about the finding of violation and the penalty to be imposed. I'll start with a discussion of the violation. Both of those, the violation under this statute requires two separate things to be shown. First, that the original donor, the contributor, directed or earmarked the funds to a particular purpose and to flow through another. And second, that the candidate was aware that that happened, at least to show this particular violation on the part of the candidate. Candidate has to know about the earmarking, which presupposes that there was earmarking in the first place. Where the hearing officer's findings, I think, are lacking and problematic are, first, whether there's sufficient evidence of the earmarking in the first place. And that has to start with the donor. There needs to be some action, some affirmative step by that donor to, in the words of the statute, direct contribution through another. The fact that it flows through another isn't enough. It has to be directed by that donor. So it's earmarked at the time that it leaves that donor's hands. Not possible for someone else to retroactively come in and create an earmarked contribution. So an important point in this picture is that giving to a political action committee, to a PAC, just knowing that that PAC supports particular candidates, that in itself is not enough. That's routine. There was testimony that PACs do that all the time. For there to be earmarking, there has to be some restriction or limitation and an instruction or evidence of that direction that the money be used only for that particular candidate or only in a particular way. The question then in this case is, what is the evidence that Gary Plant, acting as manager of the sheriff's posse entities, provided that type of limitation or restriction on the contributions that went to Adelante Sandoval? His testimony under oath was that he did not give that type of instruction. His deposition testimony, which was admitted at the hearing as testimony, is that he understood that PACs can support candidates, that they can do so in a variety of ways, including doing mailers, advertising, or giving money directly to candidates, that all those ways are on the table, that he gave no specific limitations on the contributions from Sheriff's Posse to Adelante Sandoval. Nobody else came in and testified that they heard him give that limitation or give that instruction. So the keystone piece of evidence that the general counsel is relying on is the testimony of Chris Dahl, where he says, I had a conversation with someone and that person told me that Gary Plant wanted things done in a particular way. By this commission's rules, the rules of evidence apply to these hearings. So what I ask the commission to consider is whether that testimony by Chris Dahl should have been admitted, and if so, for what purposes was it admitted and how could it be considered? So what Chris Dahl says is that he has a conversation with someone and he testifies he doesn't remember who. It may have been Donnie Leonard, it may have been the respondent, and that person made claims about the intent and the requests of Gary Plant. So what we're dealing with is hearsay, and it's two layers of hearsay because it's the first layer, Chris Dahl testifying about what he was told, and then what that other person is saying about Gary Plant and what was attributed to Gary Plant. So the general counsel says, well, it's not hearsay because it's not admitted for the truth of the matter, it's for people's knowledge and so on. But to establish that Gary Plant wanted the contributions used in a particular way, that's the truth of the matter, that he wanted it done the way, that he wanted the contributions to flow in that way. So that is for the truth of the matter. It's not just for someone else's knowledge, because someone else's belief doesn't establish that initial earmarking from the donor at the time he makes the contribution. Thing is, all the other evidence that they point to as evidence of a violation depends on that initial earmarking. If that initial contribution is not earmarked, then there's no earmarking to know about. These other things, whether it's a text message or a thumbs up emoji, are innocuous. Certainly asking about how to report $10,000 shows only that there was perhaps a suggestion that Adelante Sandoval, as a PAC, was going to give to the campaign. Without presupposing that Gary Plant attached instructions to those donations and attached limitations to them, then these other text messages don't show any knowledge or anything except the PAC to the campaign. For that reason, I would ask the commission to find that there was not substantial evidence of earmarking, thus not substantial evidence of a violation. And second, the evidence that the respondent knew about any of this is slim to none, given that the undisputed facts is that all this, if anyone had anything to do with the contribution from Gary Plant to the PAC, it was Donnie Leonard, who went to the bank and took possession of the checks and so on. it was not established, to my mind, in the hearing that he was an agent of the respondent. I don't think there's any case law that says someone who's just by virtue of having the label of being a campaign volunteer is an agent who speaks for the campaign on all sorts of topics. Finally, I think that on the violation side of it, there's a concern about what it would actually mean for candidates running campaigns if this were upheld as a violation in the precedent that it sets. Concerns about how exactly they're meant to book this type of transaction in a way that will still allow accounts to reconcile if it's listed as 10,000 from Adelante Sandoval, which has to be reported because that was on its face the contribution that was received, as well as background transactions about where Adelante Sandoval received that funding. On the penalty side, the statutes are very clear that all these penalties are discretionary. On the forfeiture side, the statute says it may include forfeiture. On the pure penalty side, it says up to $1,000. So the question is there a basis in the record to, if the violations are upheld, is there a basis in the record to overturn the hearing officer's determination of the appropriate penalty? What's interesting to me is the suggestion from the general counsel that in considering all these nuanced issues of credibility and circumstantial evidence and the inferences to be made from them is that the hearing officer got it exactly right on the violations, but completely missed the mark on the presence or absence of bad faith and the appropriate penalty to be given. I do agree that I think what we're dealing with on both sides of this house is a substantial evidence standard that is fairly deferential to the hearing officer, and that to reverse either part of that, the commission would have to find on that particular aspect that the findings were not supported by substantial evidence. What's interesting to me is the argument from Mr. Boyd that, well, the hearing officer didn't explain that there was little evidence of bad faith. Well, that's interesting because if there's a lack of evidence, I'm not sure what additional explanation can be given other than there was no evidence of it, which is consistent with the record. Especially in this case, if you look closely at the hearing officer's findings, he leaves open, and I think this may have been what was driving him on the bad faith side. He leaves open the possibility that the knowledge that he found to support the violations is not personal knowledge of the respondent, but deemed or attributed knowledge to the campaign by virtue of the Campaign Finance Reporting Act, which does say a candidate is deemed to have approved of any solicitations or acceptances of contributions. So the law says that, fine. If there's adequate finding that this all happened, it gets attributed to the candidate, fine. But I do think that speaks to whether there was bad faith or not. Certainly, if there's direct evidence that the candidate knows of something, much better case for bad faith than something that is deemed by the operation of law and imputed to the candidate for that reason. As an example of what bad faith in this circumstance or in these types of cases really is, I would encourage the commission to consider a case cited by the general counsel in his brief, the Toledano case, where bad faith was found based on a political party official accepting a check, not alerting the other officers of the political party, opening a new account, depositing the money, likely altering the check to match the name on the new account, using the money to print mailers to support a candidate who the original donors had already maxed out to. I think that's a good example of bad faith. And that's just not what we have here, where the sheriff's posse entities were not prohibited from donating to the respondent. They had not maxed out. Respondent could have received this money. I think the hearing officer found a reporting violation more than anything, because there was no evading contribution limits or evading restricted donors in any sense. Finally, I think it's important that the Constitution, federal Constitution, state Constitution, as well as the State Ethics Commission Act, give the respondent a right to defend herself at a hearing. It's not appropriate that the penalty should be increased on her because she chose to exercise that. Even granted, the hearing officer made credibility assessments going into this, there was deposition testimony by Gary Plant that he gave no earmarking instruction at all. So for the respondent to choose to go to hearing in those circumstances should not be something that's held against her. And I don't think it would be constitutional to consider the fact that she requested a hearing in determining punishment. If I may have a moment.
Sure.
Commission. The last I want to make is on the ability to pay. The opposing side's brief did attempt to introduce some facts that weren't presented at the stage or anywhere in the record before, which I think is not appropriate. What is in the record, and it was part of the original complaint made by Mr. Eichenberg, is that at least prior to winning this election, respondent spent a period of time on unemployment benefits, which I think that's the only evidence in the record regarding ability to pay. So I thank you for your time, commissioners and Mr. Chair. Happy to address any questions.
Thank you very much, counsel. Sure. Commissioner Bluestone.
Thank you, Mr. Chairman. Thank you, Mr. Dollar. Appreciate the briefing and your argument. A few questions. First, if we accept the hearing officer's findings of fact and his conclusions of law, that there were violations that occurred, where is the substantial evidence in the record to support that no forfeiture should be?
Mr. Chair and Commissioner, the evidence to that point, I think, would be the fact that the sheriff's posse entities were not restricted donors. They're allowed to contribute to candidates for treasurer. They're not people who do business before the state office of the treasurer. They had not maxed out. So it wasn't like they had already given the maximum contribution and then were kicking in an overage. It is just the fact that these were not, as I understood the hearing officer's findings, it was not reported correctly. So if we accept the hearing officer's findings and facts and conclusions of law, the only thing that should have been different that didn't happen is that on the campaign finance reports, there should have been a note in the memo section beneath the Adelante Sandoval that says something to the effect of funds from sheriff's posse entities. So that's why I think forfeiture is not necessary, is because not that the money couldn't go to respondent, but that the source should have been identified if you accept everything the hearing officer found.
And as you say, if you accept everything that the hearing officer found on the findings of fact and the conclusions of law, that there were the two violations, if there isn't some order of forfeiture, then doesn't the respondent get to have the full benefit of the unlawful amount that the hearing officer determined was unlawful?
Well, certainly there's still, Mr. Chair, Commissioner, the penalty that was imposed. And perhaps I'm reading his findings a little differently in that I don't see that the amount was unlawful, but that the reporting was improper. And so given that my understanding is she could have received it anyways and would have been able to keep it and use it if only the campaign reports had been a little bit different. That's why he didn't order forfeiture.
And my final question is on the last point you were making about ability to pay. Wouldn't that support for consideration of that factor as well as the other factors that we talked about before? Wouldn't that support a remand to the hearing officer to investigate the ability to pay as one of the factors that should be considered in the determination of any forfeiture or penalty amount?
Chair and Commissioner, yes, I think if this commission determined that the penalty is not supported by substantial evidence in either direction, too low or too high, that the remand is appropriate, because I'm not sure that this commission's rules allow it to substitute in its own judgment on the amount rather than sending it for reconsideration.
Thank you, Mr. Scott.
Commissioner McNeil? Baker?
So if I understand the argument, Mr. Boyd wants the respondent to pay an additional fine of $1,000 and wants the respondent to pay $10,000, which government feels inappropriate. Is that your understanding?
Chair, Commissioner, that is my understanding of Mr. Boyd's argument.
And Mr. Boyd, is that your argument?
Am I,
Yeah.
Chair and Commissioner Baker, yes, the hearing my argument is that the hearing officer found two violations for which $2,000 civil penalties applied, should have been imposed. And separately, because the hearing officer found an unlawful contribution, that the hearing officer should have ordered forfeiture of that unlawful contribution.
And I'm going to have to, at some point, defer to the people in the room who have actually run for office. The $10,000 unlawful contribution, if the respondent has campaign funds left over from the campaign, is she allowed to use those funds to repay, so to speak? Or does she have to dip into her personal funds?
Chair and Commissioner Baker, I don't know the answer to that. I believe that campaign funds can be used, and Mr. Boyd and I have had some discussions that contemplated that, but I can't point to the statute that says that. And Chair and Commissioner Baker, my client is telling me that, as a matter of fact, there's not that much campaign funds in the account at this time.
Do you have any comment, Mr. Boyd?
Chair and Commissioner Baker, I've reserved time for rebuttal, so I'm not going to get beyond this, but yeah, I agree. There is a regulation promulgated by the Secretary of State that permits a candidate to use campaign funds to satisfy a civil penalty under the campaign.
And if the campaign funds are insufficient, then the balance comes out of the candidate's own money.
Chair and Commissioner Baker, the candidate could also solicit contributions to their campaign, satisfy that penalty.
I don't want to get into the weeds on campaign finance. And so I'm gonna not ask my next question. What are too late?
Too late, you're already.
I mean, I'm gonna ask it because I'm curious.
Okay.
I mean, if Ms. Montoya says, you know what? I don't really like being treasurer. I'm not gonna run for reelection. And therefore, I'm not gonna solicit money for a campaign that's never gonna happen. So the money for a fine would actually come out of her pocket as opposed to campaign contributions.
You're looking at me, Chair, and Commissioner Baker.
I'm not looking at you, I'm looking at him.
To be brief, I think that there have been arguments about what's in and outside the record about as to the arguments that have been made by counsel. I don't believe that there is anything in the record on this point of whether Ms. Montoya intends to seek reelection.
Understood. And she could change her mind 5 times every day. All right, thank you.
Commissioner Castillo, anything?
No, I'm having.
Commissioner Solomon?
Thank you, gentlemen, for bringing this up. I just wanted to see how you framed up the actual contributions in terms of one action from 2 sources or 2 separate actions.
Chair and Commissioner Solomon, I think, and I'm sure Mr. Boyd will correct me if I'm wrong, but review the undisputed evidence of how the checks went from the sheriff's posse. We've been calling them entities collectively, but there are 2 separate LLCs. They have very similar names: Sheriff's Posse Road 1 LLC and Sheriff's Posse Road 2 LLC. 2 separate entities. Gary Plant is the manager for both of those. And what I believe is undisputed is that Gary Plant went to the bank and did a $5,000 check drawn on the account from Sheriff's Posse Road 1 and a $5,000 check from the account drawn from Sheriff's Posse Road 2. Both those checks go to Adelante Sandoval, the PAC. And then about a week later, there is one check for $10,000 from Adelante Sandoval to Laura Montoya for treasurer. I hope that answers.
Yeah, I think I can make sure I understand.
Anything else, Commissioner Solomon? No, thank you. Commissioner Villanueva, do you have any questions?
I just have one quick question, please. So the checks that were received from Adelante Sandoval were in September 21st or 2021 or thereabouts, is that right?
So, Chair and Commissioner, my understanding of the timing, and I believe, again, this is just undisputed facts in the record, September 21st, 2 checks go from the Sheriff's Posse LLCs to Adelante Sandoval. My recollection of the record is 6 days later, September 27th, 1 check goes from Adelante Sandoval to respondent's campaign.
Okay, so is it also so that there were 2 checks that were reported as donations in April of 2022, on the second biannual report. Would that be delinquent reporting or not?
So, Chair and Commissioners, I'm happy to explain that. And again, I'll represent that. I think this is undisputed. The reason, so there's no allegation in this that was untimely reporting. The reason that there was an amended report in April of 22 is for a separate issue that had to do with a transaction that Adelante Sandoval was originally reported because Chris Dahl made it on his personal account, but it was supposed to come from Adelante Sandoval, created a potential overage. That money was refunded, and to address it, the respondent did a refund and a amended report. That of $100, that was something that came out early in this process, but it was not something that the GC found probable cause for, not something that was pursued at the hearing. And I think that was resolved. There's a separate thing that you may be asking about, Commissioner, which is why on that report, it looks like there were two transactions from Adelante Sandoval, even though I'm telling you there was one check. The reason being is because in New Mexico for that election cycle, the contribution limit for primary was $5,200 and the contribution for general election was $5,200. Now, donors are allowed to give more than that, but the candidate has to book them separately. So this amount is primary funds and this amount is general election funds, which is why if you look at the report, it looks like Adelante Sandoval $5,200 and $4,800. That's the $10,000 check being reported. I believe that that is also a non-issue in this, but I'm offering that to make sure we're all on the same page with respect to that. It's kind of in the weeds, but I appreciate the commission's indulgence. Thank you.
I understand. Thank you very much.
Hey, so I have a question, counsel. The act, case law, nothing I have heard any lawyer says that if there is a violation that is found to have been knowing by the candidate, there must be a forfeiture. That's not what it says, right?
That is
So that presumes that knowing is not sufficient in order to kick that in. There's got to be something beyond knowing, correct?
Chair, I agree with that. And I would also note that there is a provision in this commission's enabling statute that says willfulness needs to be found by clear and convincing.
Correct. Okay, I thought I could have asked him that, but he gets to respond to it now. So you have some time if you care to thank your rebuttal, Mr.
Chair and Commissioners, thank you. I'll start with the question you just asked, Chair. The section governing civil penalties applies to all violations of the Campaign Reporting Act. And it's not just a straw contribution that is an unlawful contribution. There are other contributions that can be found unlawful. There are other forms of solicitation, regulated party solicitations, contributions that are in excess of the contribution limits. So I do not believe that that section speaks to what evidence is or is not required to show to justify a penalty, just that there is discretion in the deciding body to award either a maximum penalty or vary downwards.
Right, and that's kind of my point. There's something beyond simply a finding which he made that the respondent herein knew. So lack of anything beyond that would seem to support the respondent's position, I think. The hearing officer didn't find by necessity in his findings and conclusions, there was no evidence beyond her knowing.
Chair.
Knowing, simply knowing does not kick in the forfeiture.
Chair and Commissioners, I believe that the discretion there has to be informed by some set of reasons, whether it's
Where do you
to
get
go
that?
to the top or the bottom.
That's a concept I'm not familiar with, so tell me where you get that.
Well, under the State Ethics Commission Act, the hearing officer is required to conduct a hearing and find whether a violation has occurred
Correct.
and whether a civil penalty should be imposed, and is under a statutory duty to provide the reasons for his decision.
And he did in fact impose a civil penalty.
Correct. And so on appeal, the commission's duty is to understand whether is to ascertain whether there is substantial evidence for that
And he
determination.
provided no substantial evidence as grounds for forfeiture, would be the way I would. I mean, I think you're right. If he says she needs to forfeit the 10,000 because of X, Y, and Z. There's a proving of a negative that I'm not quite willing to go with. I'm finding that she knew, but I'm gonna make these other 10 findings that shows that it's not willful. That's not something that resonates with me.
Chair, and I have some other points to make, but the last point I'll make on this issue is that there was no requirement of a willful that respondent knew about this statute at the time she received this contribution. That was not an issue at the hearing. And so,
But the fact, I mean, that would maybe even strengthen it. But you and I are speaking two different languages, but it seems to me that if you're going to do something more, that requires an evidentiary substructure and structure, which here is missing. I agree with you, it's missing, but I think that supports the proposition of the respondent as to the $10,000. At any rate,
I'll move on.
we've better go.
Chair and Commissioners, the second point I want to make is that the respondent, the respondent's attorney represented that the hearing officer left open the chance that this was all a kind of right hand not knowing what the left hand was doing type situation, that Donnie Leonard was going out and making this solicitation, getting the checks, all unbeknownst to the respondent, and that she didn't, to the extent there was some kind of agreement to conceal Mr. Plant's involvement, that she was wholly ignorant of that. The hearing officer found this is on record proper 648, that when Miss Montoya accepted the $10,000 donation from the PAC, she knew that the donations had been made by another person or persons through the PAC. So the hearing officer did find that there was subjective knowledge on the part of respondent that this contribution was an unlawful contribution, or that it was made as a straw contribution. Finally, on the hearsay point, I think that respondent's argument as to the hearsay it really proves too much, because the respondent's argument basically means that unless the original donor and the candidate testify at deposition or at a hearing that they knew that this contribution was a straw contribution, that they provided this instruction, there can never be any proof of a straw contribution, because any testimony by others as to what the candidate's knowledge was or what the original donor's intent was is necessarily based on out-of-court statements made by those individuals at the time the contribution was made. Finally, on bad faith, that's just one factor that the courts have recognized as appropriate to consider. I think that the Fergetch court talks about these factors as non-exclusive. The decision-making body does not need to make a finding against the respondent on each of these factors in order to assess a maximum penalty. Those factors are just recognized as factors that the body may consider in deciding to fix a maximum penalty, a middle penalty, or no penalty at all. I think that the Ted Haley case is the case that I would hold up as the best application of the good faith prong. And that case, talks about all the respondents' efforts to both address the violation once the violation had been found, and also discusses how really it was a mistake of law case. And so I think that perhaps bad faith is a misnomer. I think that if the hearing officer is going to find no penalty and explain his reasonings for doing so, he should have found good faith on the part of the respondent. He should have said that it's not just that there's little evidence of bad faith, it's that in fact the respondent acted in good faith and either the law was unclear or there was some confusion on her part, and that gives rise to a finding that a maximum penalty is not appropriate. If the commission the commission should not treat any one of these factors as dispositive. It needs to consider all of them in deciding what the appropriate penalty is. I think I'm good. Thank you.
Thank you. Is there anything that he raised in his rebuttal that you would care to respond to?
Yes, Chair and Commissioners.
Please.
The hearing officer's findings do refer at other points to the knowledge being deemed to respond in. At page 650 is an example of that, which is consistent with her testimony at the hearing that nobody told her about this going on, and the testimony of others that they didn't communicate what was going on to her. And the last point I would like to leave the commission with on this issue that Mr. Boyd raises of the hearing officer being required to explain his findings. For when he says there's no evidence or little to no evidence of bad faith and public harm, that is the explanation. I'm not sure what more he could possibly say than I didn't find any evidence in this person's testimony, no evidence in this person's testimony, no evidence in this exhibit. If there's no evidence, there's necessarily not going to be a drawn out explanation of where there was no evidence. And it was their burden to present any such evidence. So I thank you, Mr. Chair and Commissioners, for your time this morning.
Thank you. Anything else? Yes, Mr. Bluestone.
On that, Jeff. But wouldn't it also be entirely appropriate for this body to conclude that contrary to the finding of no public harm, there was harm when there was not proper disclosure of where the money was coming from? Consistent with the Campaign Reporting Act's, one of its primary goals to let the voters know where the money was coming from to finance campaigns. So couldn't we respectfully disagree with the hearing officer, saying, even though he said there was no public harm, there was in fact public harm by the mere violation of laws that he found?
Chair and Commissioner, in my opinion, what I think you could do is say, hearing officer, you got it wrong on public harm, reconsider it. I don't believe this commission can say, we find public harm based on this piece of the record, this piece of the record, and therefore we're substituting a new ruling in.
Thank you.
Anything further?
Yeah, I'd just like to say, I'd like to thank both counsel. I thought that the briefs were very good. I thought the oral argument was very good. And I want to thank you. This has been a lot.
Yes. Thank you all.
Nothing further.
And we will adjourn to deliberate on an appropriate motion, but you all are excused.
Thank you.